tight-fitting masks and sitting well-spaced on the red upholstered seats, the view of the 9 justices was direct and unobstructed. The court had scheduled the morning hearing after letting a Texas abortion ban take effect in a midnight order on September 1st. For 2 months, women in America's second most populous state had been living without the right to abortion. The Supreme Court had guaranteed that right in its 1973 Roe v. Wade milestone and reaffirmed it many times, most definitively in 1992's Planned Parenthood of Southeastern Pennsylvania v. Casey. The Texas legislature had flouted those precedents and the Constitution and prohibited abortion after the first sign of fetal cardiac activity, roughly 6 weeks, a point when many women do not yet know they are pregnant, and a point, too, at which fetal heart valves have not developed, making heartbeat law a misnomer. So far, the Supreme Court had gone along with Texas and had rejected requests to suspend the ban until its validity could be assessed. The justices' action in the case illuminated how much the court had changed and no longer could be counted on to protect certain individual rights. Pregnant women who wanted an abortion were traveling to Oklahoma and other nearby states. Those without the money to leave Texas were panicking, forced to end their pregnancies on their own, many using misoprostol and other oral medications, or to carry an unwanted pregnancy to term. Texas abortion clinics challenged the new law, declaring in a petition for a writ of certiorari, "Texans are in crisis." The clinics implored the Supreme Court to scrutinize the unusual statute, which gave private citizens the right to sue physicians, clinic staff, or any person who helped a woman obtain an abortion. The Texas Attorney General argued that the justices lacked jurisdiction even to hear the case because the legislature had written the law, shrewdly, in a way that let private individuals, not state officials, enforce it, thereby shielding officials from lawsuits. The statute granted a minimum of $10,000 in damages for each abortion successfully challenged. The threat of unlimited litigation and ruinous financial liability was forcing clinics to stop most abortions. When the Supreme Court let the Texas law go forward on September 1st, Chief Justice John Roberts dissented, joined by the senior liberal justice Stephen Breyer and Justices Sonia Sotomayor and Elena Kagan. The moment revealed a loss of control for the usually persuasive leader of the bench. Surely no proponent of abortion rights, Roberts was nonetheless astonished that a state would attempt to invalidate decisions tracing back nearly 50 years to Roe v. Wade. Only the Supreme Court itself had such power. The 5 conservatives who controlled that September 1st action sided with state officials, saying that the heartbeat bill's challengers had failed to show that they were likely to succeed on the merits of the question or be irreparably harmed if the ban took effect during litigation. The applicants now before us have raised serious questions regarding the constitutionality of the Texas law at issue, the majority wrote in the unsigned order, but their application also presents complex and novel antecedent procedural questions on which they have not carried their burden. The majority brushed aside arguments about women awaiting immediate care, women who lacked the means to travel out of state, and women who, if delayed for even a few more weeks, would be affected by Texas's separate deadlines for obtaining an abortion at all. After that defeat, abortion clinics persisted with subsequent requests to the court, and the U.S. Department of Justice entered the fight. Lawyers for President Joe Biden's administration filed a suit asserting that, for half a century, this court has held that a state may not prohibit any woman from making the ultimate decision to terminate her pregnancy before viability, with viability defined as the ability of the fetus to live outside the womb. The lawyers warned that if Texas was not stopped, any state could effectively nullify any constitutional decision of this court, including those favored by conservatives. For example, allowing handguns in the home or lifting restrictions on corporate spending in political campaigns. The public commentary on the September 1st late-night opinion had been sufficiently harsh that less than 2 weeks later, Justice Amy Coney Barrett gave a speech in the court's defense at the Sealback Hilton in Louisville, Kentucky, at an event celebrating the University of Louisville's McConnell Center.